Welcome to this lecture on planning law, in particular reactive planning powers. My name is Fred Hopma and I'm lecturer in planning and development law. The topic of this video lecture, planning law, is a topical issue. Actually, planning law is an inevitable aspect of real estate development and infrastructure development. Every real estate project and every infrastructure development project has to deal with planning law issues. Let me give you a couple of examples from the Netherlands. For instance, the motorway A4 in Midden-Delfland, an area between The Hague and Rotterdam. Here, this project had to deal with local resistance from inhabitants and environmental pressure groups, and also from certain municipalities. Decision making took many years. An example of planning law related to a civil engineering project. Here's another example. The redevelopment of Utrecht railway station area in the center of the Netherlands. For this project, hundreds of permits were needed. Permits for demolition, environmental permits, etc., etc. The coordination of all the needed permits was a real task for the project organization. And here's a third example. The Haagse Hogeschool in The Hague, the University of Applied Sciences in The Hague. For this project, expropriation was needed. So, existing rights were taken away from the land so that the new development could take place. 3 examples of infrastructure and real estate projects that had to do with planning law, as every project has to do with planning law issues. Is it a recent phenomenon, planning law? Actually, no. Even in the Middle Ages, there were regulations regarding the defense of the local community, the fire safety of buildings, the structural reliability of buildings, the concern for the appearance of city and land, so building aesthetics, the provision of necessary living space, so making land available for buildings, residential protection, for instance the protection against trouble resulting from the building activities of neighbors, and finally traffic safety. To illustrate this, let's go to an example more than 600 years ago. An example regarding regulation for public thoroughfare in the city of Amsterdam in the year 1413. The regulation says that awnings cannot be more than 7/4 yards wide and have to be at least 8 feet above the ground. So, even then, in the Middle Ages, very detailed regulations regarding building activities. Well, apparently nothing has changed. Nowadays we also see very detailed regulations, and there are even complaints about over-regulations. Apparently governments, in particular local authorities, have always felt the need to regulate A. land use. This answers the question for which purposes land may be used, for instance agriculture, housing, streets, public green, industry or dams. And B. building plans, so heights, structural safety, fire safety, aesthetics and physical quality like light, fresh air and noise. Through the ages, governments have always felt the need to regulate these kinds of issues. And the reasons for regulations, of course, is the public good or the general interest. Apparently, the local authorities need to regulate these issues to make sure that the public interest is served well. Nowadays, even many constitutions relate to this. For instance, Article 21 of the Constitution of the Netherlands: it shall be the concern of the authorities to keep the country habitable and to protect and improve the environment. But an important question is, how far can governments go in limiting the freedom of private parties and persons? Or, what are the boundaries of governmental interferences? The answer to this question lies in the legality principle. The legality principle is the answer to the question, why do we have so many rules? And the answer to the question, what are the boundaries of governmental interference in private parties' building initiatives? Let me explain. The legality principle implies that governmental interference and limitation of the freedom and possessions of its citizens is only justified if there is a law giving the government the power to do so. If we apply this principle to land use and building plans, it means that no one can be forbidden to use his land or to build at one's own discretion unless there is a democratically approved act that regulates this subject. The legality principle has two effects. First, there is equality of all for the law, and second, there is legal certainty, because beforehand it is clear what the powers of the government are. Following the legality principle, there are many acts giving the government the power to, for instance, end land use that is in conflict with a governmental plan. Likewise, there are acts giving the government the power to, for instance, demand a permit from building initiators. And in the Netherlands, the most important acts in this respect are the Environmental Licensing Act and the Spatial Planning Act. So, to answer our question, where lies the limitation of governmental interferences in private parties' activities? The answer is, the limitations lies in laws. Government only has powers insofar as given by law. Looking at the powers given to government according to the legality principle, we can make an analytic division into two kinds of powers: reactive powers and proactive powers. Reactive powers are powers related to government reacting to private sector initiatives. An example is the environmental permit. Through the permit, local government accepts or denies private parties' building initiatives. Proactive powers relate to government taking the initiative to development. For example, expropriation for infrastructure construction. In this video lecture, the reactive powers will be discussed. In another video lecture, the proactive powers will be discussed. As said, the most important reactive power of government is the power to demand an environmental permit for a building project prior to any building activity. Article 210 Environmental Licensing Act in the Netherlands. An important question is, how are applications for environmental permits for a building project tested? Well, there is a framework for this. Article 210 of the Environmental Licensing Act stipulates the grounds for applications. The grounds applications are tested against. Applications for environmental permits for a building project are tested to see if they are in line with several grounds for refusal. There are 6 grounds for refusal. The land use plan in Dutch bestemmingsplan. If the building project is in conflict with the land use plan, the permit will not be granted. The land use plan relates to the permissible use of land and buildings. The building decree bouwbesluit. This document relates to the technical quality of the new building or infrastructural project. The code regarding the external appearance of buildings, welstandsnota. This document relates to the aesthetic quality of the new building, the building ordinance, bouwverordening. This document relates to the quality of the soil, amongst other things. And the advice of the Committee for Tunnel Safety and the development plan, the site development plan, exploitatieplan. This relates to the recoup of municipal costs for public facilities. We will now discuss the first 4 grounds to test applications for environmental permits against. So the land use plan, the building decree, the code regarding the external appearance, and the building ordinance, also sometimes called building bylaw. So, first, the land use plan. If the application, so the technical drawings for the building or infrastructural project, is in conflict with the land use plan, the permit will be denied. What does a land use plan regulate? It regulates functions of buildings, types of dwellings, for instance apartments, percentages of affordable housing, building heights, alignment, so building lines. It may also regulate roof shapes, building masses, permissible use, sight lines, densities. These are not compulsory elements, but all elements of land use plan we regularly encounter. Please note that these topics relate to the functional partitioning of space plus the spatial quality. So land use plans not only relate to functional partitioning but also spatial quality. And please note that land use plans affect public space and privately owned land. So not only privately owned land, they also apply to public space. Some examples of land use plan maps. They can be really rough, only holding 2 land use objectives: city expansion and green. But they also can be quite detailed and contain 10 or more land use objectives, bestemmingen in Dutch. They even can be extremely detailed and hold exact regulations regarding plot ratios and building heights. It's up to the municipality to decide how detailed they want to draw up the land use plan. A land use plan not only holds maps, but also written instructions. Here's an example of land use plan instructions that belong to a land use objective, low-rise houses, on the map. So together with the land use objective, low-rise houses on the map, you will find written instructions that may read like this. 1. Land on the plap indicated for low-rise houses is designated for houses and accompanying access roads, gardens and grounds. 2. At the land aimed at in section 1, exclusively low-rise houses can be built, accessory buildings for domestic use and lock-up garages, on the understanding that A. The height of the gutter of a house is at maximum 6 meters, B. The surface area of a house is at maximum 100 square meters, and C. The height of the accessory buildings for domestic use and the lock-up garage is at maximum 3.5 meters. So, applications for environmental permits for building projects need to comply with the map, but also the written instructions. If not, in principle, the permit will be denied. So far we have been talking about the land use plan, but there is another plan usually present as well, a master plan. We can ask ourselves, what are the differences between a land use plan and a master plan? Well, here are some characteristics of a master plan. It's a flexible plan. There's no fixed scale, no fixed procedure, no fixed contents. It has the ability to innovate with regards to signals from the market. It's a market-oriented plan. It can easily be changed if market circumstances change. It acts as an instrument of communication between all the parties involved in the development or redevelopment of an area, and thus it can be used as a process management tool. How about the legal force of a master plan? Well, a master plan in itself does not have legal force. No one is obliged to comply with a master plan. Applications for permits in the Netherlands are not tested against a master plan. Voluntarily compliance is naturally always possible. Master plans do not have a legal basis. There is no act that refers to master plans. Let's look at the characteristics of the land use plan procedure. First characteristic is that of democratic legitimization. It means that the land use plan is adopted by the municipal council, so the chosen councillors. And because the chosen councillors adopt the plan, we can say there is democratic legitimization of the new plans. 2. Possibilities for affected citizens and organizations to oppose against the draft of a land use plan. According to law, citizens and organizations can oppose against such drafts. And 3. There is final judicial settlement by the independent administrative judge. If interested citizens and organizations feel they are disadvantaged by the plan, oppose against the plan, they can go to an independent judge, which in the Netherlands is the district court, or in case of higher appeal, the Council of State. We now come to the question, why is, from a legal viewpoint, the land use plan the most important spatial plan? I give you 2 reasons. First, applications for environmental permits for a building project are tested to see if they are in line with a land use plan. They're not tested to see if they're in line with a master plan. So the land use plan, the local land use plan, is most important. 2. Expropriation is possible on the basis of a land use plan. Expropriation only can be used if there is a legally adopted plan, and the land use plan is a plan which forms a basis of expropriation decisions. The first bullet refers to reactive powers of government. The second bullet, expropriation, refers to the proactive powers of government. This ends our discussion of the land use plan, the first ground to test applications for permits against. Let's go to the second ground for refusal of environmental permits for a building project, the building decree, also called building code, a set of technical regulations for infrastructure and buildings. These are regulations concerning the minimum technical level, load-bearing capacity, stability, fire resistance, ventilation, acoustic insulation, the energy performance of the building. The energy performance coefficient is an expression of the maximum amount of energy a building may use. Ramps, and for example the minimum amount of daylight in any one room. These are examples of minimum technical levels as indicated in the building decree. But also housing quality is regulated in the building decree. For instance, the minimum surface area required for a toilet, or the minimum distance required between the floor and the ceiling in dwellings. At this moment 2.6 meters in the Netherlands. Generally, it is the task of the structural engineer to take care that the structure complies with the regulations of the building decree. Note that the building decree is a national document with the legal status of an order in council based on the Housing Act. no possibility exists for local councils to add new technical regulations or to elevate the level of regulations locally. Therefore, in principle, the same regulations apply to each municipality in the Netherlands. This makes it easier for producers to put products on the market. Let's go to the third ground for refusal of environmental permits for a building project: external appearance, so aesthetics. This isn't a new thing. Even in the Middle Ages it was important. The height of a structure was important. The higher, the more respectable. And the choice of materials as well. Roofing with slates would receive more subsidy than plain roof tiles. But through the years there have always been ideas to abolish the external appearance test. So to deregulate this. And the idea was that this test implies paternalistic behavior of government. However, current legislation still holds the external appearance, although municipalities may decide for parts of the municipality or even the whole of the municipality to not use it. There are only a few municipalities in the Netherlands that abolish the external appearance test altogether. This is the regulation in the Housing Act. It says the Municipal Council adopts a policy document on external appearance, containing policy regulations which at least include the criteria that the municipal executive applies in its assessment whether the appearance and the location of a structure or site to which the environmental permit application applies, considered either separately or in connection with the surroundings of the expected development of the said surroundings, are in conflict with reasonable requirements of external appearance. So this relates to the building, the architecture and its surroundings, the urban design. In effect, the design of a building is tested against the criteria of the policy document. So, new housing initiatives are tested against criteria. But also, for instance, a gas station and a shed. And even additions to existing buildings, for example in a garage, are tested against the criteria. This means that, for instance, a wooden garage is not allowed if the main building is of bricks. Also, a garage that is in line with the facade of the original building, the houses, will not be accepted. Also, a garage that is higher than the first floor level will not be accepted. Only this type of garage will be accepted from the viewpoint of external appearance. That concludes the third ground to test applications for building permits against. Now the final ground, fourth ground, the building bylaw, building ordinance. One of the topics of every municipal building bylaw is the regulation that the applicant of a building permit, of an environmental permit for a building project, presents a recent soil survey report to the municipal executive. The applicant has to show that the soil is not polluted. If the soil is polluted, there may be a problem and decontamination has to follow, unless the project is a project in which there will be no use by humans. For instance, a shed to simply store goods or a parking lot. There are many more regulations in the municipal building bylaw, but for now we stick with discussing the soil survey report. Okay, we now covered the most important grounds to test applications for an environmental permit for a building project against. This concludes our discussion of the reactive planning powers.